filed by a resident of Dallas County, which is the one and only fact that connects this lawsuit to Dallas County at all. But this one lone fact cannot overcome the other multiple.
Right. There's, as I understand it, I've never dealt with this particular venue provision. There's a venue provision that says that if it's a case involving a trust, the trustee can file it in the trustee's home domicile. That's the basis of this?
That's the basis for the plaintiff filing it in Dallas County, I suppose. But that provision is under Chapter 115 of the Texas Property Code, which we'll just refer to as the Trust Code. And that venue availability is inferior to the venue requirement in the Texas Estates Code. And we can go through that statute itself and we can get to why it's inferior. So if we look at, so like I said, Chapter 115 of the Texas Property Code is the Trust Code. The plaintiff, in their response to our motion to transfer venue, claims without authority that the Trust Code A applies and B supersedes any other venue provision, which is incorrect. So if you look first at Chapter 115.002 for venue under the Trust Code, it says that the venue of an action under 115.001 of this act is determined according to this section. So meaning, if an action falls into the type of actions that are enumerated in Trust Code 115.001, then venue is determined according to 115.002. So the types of actions that are enumerated in 115.001 for jurisdiction are: 1, to construe a trust instrument; 2, to determine the law applicable to a trust instrument; 3, to appoint or remove a trustee; 4, to determine the powers, responsibilities, duties, and liability of a trustee; 5, ascertain beneficiaries; 6, make determinations of fact affecting the administration, distribution, or duration of a trust; 7, determine a question arising in the administration or distribution of a trust; 8, relieve a trustee from any or all of the duties, limitations, and restrictions otherwise existing under the terms of the trust instrument or of this subtitle; 9, require an accounting by a trustee, review trustees' fees, and settle interim or final accounts; and 10, surcharge a trustee. Those are the entire actions that venue shall be determined pursuant to 115.002. This action does not fall under any of those in that enumerated list. However, the Trust Code does provide for a catch-all of sorts. And in 115.001A-1, it says that the list we just read through is not exhaustive. But in subsection D, the Trust Code says that other courts have dominant jurisdiction to that of your court in certain circumstances. One of those circumstances says that your court would lose jurisdiction if jurisdiction is conferred by law on a county court at law. As we briefed the court, the plaintiff has sued for a variety of declarations concerning acts which the executrix of an estate took while she was administering that estate. That estate was probated in Midland County, Texas. Texas Estates Code 32.005A says that, quote, a cause of action related to the probate proceeding must be brought in a statutory probate court. Now, Midland County does not have a statutory probate court, so we look again to the Texas Estates Code 32.002, which says that in the counties where there is no statutory probate court, the county court at law, which exercises original probate jurisdiction, and the county court have concurrent original jurisdiction of probate proceedings. So when we put all this together, the list of claims that the Trust Code enumerates does not include the plaintiff's lawsuit. None of her claims fall under that list, but the list is not exhaustive. But even assuming that this court does find that this action falls into that catch-all, this court would still lose jurisdiction to Midland County. The Midland County courts at law have exclusive jurisdiction over any cause of action, quote, related to a probate proceeding, end quote, in Midland County, which makes sense. If you have a county court in Midland County that appointed the executrix of the estate, that court would want to hear any complaints about acts and omissions that she took while administering the estate. So the trust code says that when jurisdiction is conferred on a county court at law, this district court loses jurisdiction to the county court at law. The estates code says that the county court at law in Midland, which heard the probate matter to begin with, has jurisdiction over any claims related to that probate. Unquestionably, the plaintiff's lawsuit relates to that probate because it seeks declarations with regard to the estate and actions that the executrix took while administering the estate. This means that the Midland County Court's jurisdiction is superior to anything contained in the trust code, and it is superior to the jurisdiction that this court would otherwise have. That's why the trust code does not control and why the estates code jurisdiction is superior to that of the trust code. In the plaintiff's briefing, she has one and only one argument against transferring this case to Midland County, and that's simply that the trust code applies. She fails to argue substantively.
Is there any case law on this about the conflict between, or not the conflict, but the interrelation between the estate code and the trust code venue provisions?
I don't know that we pulled that. I mean, the plain language of the statutes is abundantly clear. We can submit some supplementary briefing if the court would like.
Okay. Response?
Yes, Your Honor. Start from the beginning or to that point?
I mean, I really, I guess there seems to be one issue here, which is which venue provision controls here.
Correct.
And so,
and I don't know if Mr. Daigle's done. They argue like 6 other different provisions. Basically,
Mr. Daigle, I'm sorry, were you not finished? I thought you were finished.
Judge, I think you're right that the question is whether the estates code is superior to the trust code, but we would also argue that the trust code does not apply at all. And in addition to that, the other mandatory venue provisions of Civil Practice and Remedies Code 15.011 and 15.002 each require that this case be transferred to Midland. So there are multiple mandatory venue provisions which require that this case go to Midland. And in addition, the estates code, by the plain language of the estates code, says that it's superior to the trust code.
Mr. Dennis, I think that the real issue to me is does the estate code or the trust code, which of these provisions prevails or is, I guess, dominant? I'm not as concerned about the other arguments, so why don't you concentrate on that one argument? And do you have any case law that deals with the interpretation between the two codes?
So the case law says that basically non-civil practice and remedy code section 15 trump section 15. Now the probate code is outside of that, and the trust code specifically talks about probate proceeding. But what my opposing counsel doesn't discuss, and we detail within the briefing pretty extensively, and Mr. Caldwell can chime in if I get something wrong here. Basically, from page 15 to 18 of our response, we demonstrate the state code's inapplicable. So Courtney Cowden, who's the husband of the mother who's incapacitated now in Midland, he died and left these trusts, which are the subject of this suit. He died in 2004. It was subject to an independent administration, And so we've put in undisputed evidence, and that's not a venue fact that they have challenged, that his estate is not pending. Both Ellis Cowden, one of his sons, and Susan Rayborn, our client, the plaintiff in here, and his daughter, have declarations evidencing that it was an independent administration, all debts were paid, and distributions made, and those facts are undisputed. So, and it's within page 15 of our response, but we cite case law that shows that in order for an estate to be pending, that's the issue. Is there any property to be distributed or debts to be paid? And yeah, that's on page 16 of the brief. There's a footnote, footnote 34, in re the estate of Rowan from the Dallas Court of Appeals. Quote, in determining whether the estate was closed, the issue is whether the debts of the estate have been paid and the property distributed such that there was no need for further administration. Order dismissing claims pursuant to FSA did not close the estate. And so both, again, Mr. Cowden and Ms. Rayborn have attested that that 2004 estate is no longer pending, that long ago, both the debts were paid and all property had been distributed. They don't have any counter declarations contradicting it. And in a point of fact, as the court knows, the standard for factual determinations in this situation would be any probative evidence that supports venue. And in fact, I think the case law even says, even if the evidence predominated against venue, as long as there's some probative evidence that would support it. So my response is less that there's a clear case. There's a whole Baylor article, which I have, and I can refer the court to, that talks about the interplay between different mandatory venue provisions and different ways in which courts have determined. Some say we'll defer to the plaintiff. Some talk about which statute's older. In this case, we could get into that, except because they're both outside of Civil Practice and Remedy Code Section 15. There's clear case law that, for example, the Real Property Code, which he references, is inapplicable here for mandatory provision because no one's seeking an interest in property. But even if it were applicable, the trust code would trump because it's outside the Civil Practice and Remedies Code. In the situation that we really did have a probate proceeding, then you'd have to use one of those different methods to compare mandatory venue provisions. But in this case, there's no evidence that there is a pending proceeding. There's no probate proceeding. Ms. Cowden's still alive. Her husband died in 2004. The undisputed evidence is that all the debts were paid and all distributions were made. So accordingly, there's no evidence of a pending probate proceeding. And even though after we filed this lawsuit, they went out and filed a counter mirror image sort of suit in Midland County to try to get jurisdiction there, they didn't even file.
We did not file any lawsuit in Midland County.
The Swallows, his clients, filed a lawsuit in Midland County.
My clients, the Swallows, did not file any lawsuit in Midland County.
They absolutely did. If that's what we're going to debate, the mother, who's incapacitated, purportedly filed a lawsuit against all of her children and the Swallows. Now, we know she's incapacitated because Susan keeps up with her and deals with her caregivers and visits her, but the Swallows have her power of attorney. So a lawsuit was filed by the Swallows on behalf of their incapacitated mother against themselves, the Swallows, and the other children, in order to give a sort of a sham proceeding to suggest that we should be in Midland County. But again, I mean, the primary issue that Your Honor is interested in is whether the exclusive venue provision for the Texas Trust Code applies. And I'm happy to address all the other issues.
So let me make sure I kind of get this. So you're citing to the Texas Trust Code section 15.002 C1, which states, notwithstanding the sections B, B1, B2, I think this is B2, C, if the settlor is deceased, the administrator of the settler's estate is, and an administration of the settler's estate is pending in the state, an action involving the interpretation and administration of the intervener's trust created by the settler or trustee created by the settler's will may be brought in a county in which venue is proper under section B, and in the county or in the is in the county. Is this the section, Mr. Daigle, that you're relying on?
No, Judge, and I can walk you through why it does not apply.
Okay.
Okay. So the plaintiff is citing to Trust Code 15.002C1, which says that it is for an action involving the interpretation and administration of an inter vivos trust created by the settlor. And that code requirement says that an estate must be pending. That is not what we're dealing with here, Judge. If you look at 8.6 in the plaintiff's original petition, the first two declarations are concerning a power of appointment under the decedent's will, not the inter vivos trust. So we're not talking about whether the estate is pending or not. First of all, the estate is certainly pending in Midland County. There has been no finding, no order, not even a motion to dismiss that estate proceeding. So it is pending. But that notwithstanding, the declarations that the plaintiff seeks in her petition concern the will of the decedent and the special power of appointment under the will. So what do we look at when it's under the will? It is unquestionably an action that relates to a probate proceeding. The probate proceeding took place in Midland County. It is pending in Midland County. And there is no room to keep this case in Dallas County. It must be transferred to Midland.
Well, let's look at the causes of action here. Let me see in the petition.
Yeah, if you go to paragraph 8.6, that's some of their declarations. And the first two declarations are about the will.
Let me see. So they're suing for first breach fiduciary duty involving the trust, it looks like, and then a request for declaratory relief. Let me share screen this. So this is kind of an interesting issue. So a breach of fiduciary duty. So the first claim is for breach of fiduciary duty involving the trust, correct?
Correct, Your Honor.
All right. And then there's a declaration request for as to whether Margaret is validly exercised a special power of appointment under the will. This is so if it was just a breach of fiduciary claim involving the trust, I would think that it makes perfect sense to have that here in Dallas County, but these claims involving the will, that seems like that should be in Midland County, Mr. Dennis.
Yeah, and Your Honor, he's talking about the power of appointment. First, I'm lost as to which provision they're talking about, because the mandatory venue says there has to be a pending probate proceeding.
Not under the estates code.
Okay, well, which provision are you citing to? Because the briefing's all over the place.
But, Mr. Dennis, I don't need your commentary, honestly.
Can you just tell me what provision we're talking about, please?
Yes, sir. It is Estates Code 32002 and 32005.
Can you share screen that, Mr. Daigle?
Sure.
Sanchez, are you here for this hearing?
I'm not sure if you can hear me. I just checked the calendar and I believe it said 10:30, so it looks like mine is coming up in about an hour.
Okay, you're welcome
All
to stay if you like.
Thank you.
Okay, Judge, this is States Code 32.005. In a county where there is a statutory probate court, the statutory probate court has exclusive jurisdiction of all probate proceedings, regardless of whether contested or uncontested. A cause of action related to the probate proceeding must be brought in a statutory probate court unless the jurisdiction of the statutory probate court is concurrent with the jurisdiction of a district court or with the jurisdiction of any other court. And 32.002 clarifies that in Midland, where you don't have a statutory probate court, the county court at law exercises that same original jurisdiction. So reading the two in harmony, any cause of action related to a probate proceeding, it doesn't say that the probate must be pending. It doesn't say anything that Mr. Dennis wishes it said. It says if it is related to the probate proceeding, which declarations regarding
What's
Mr.
in
Couch-
32.0? It says, unless, let's see, unless the jurisdiction of a statutory probate court is concurrent with the jurisdiction of a district court provided by 32.107, does that not apply?
let me pull that up.
And while he's doing that, I would just say we address this, now that I understand what argument he's making, we address this argument on page 17 to 18 of our response, because this suit's not a probate proceeding. There's a list of specific actions that are a probate proceeding in 31.002. I won't list them all, but an action against a personal representative, an action against a surety, a claim brought by a personal representative, an action brought against a personal representative, an action for trial of title to real property, and an action for trial.
Isn't this in
right-
some sense
What are you
brought
reading?
against the executor, though?
It's not. So
What are you
the
reading?
defendant, hold on 1 second. The defendants are the
What
swallow.
are you reading, Mr. Dennis? What law are you reading?
I'm
Sorry, I
reading
didn't catch
from
that.
page 17 to 18 of our brief, which is quoting as Texas Estates Code, section 31.002, a matter related to a probate proceeding, and there are specific matters that are defined as a probate proceeding. And so it's not a probate proceeding. It's also not pending. We deal with that law. So they're essentially trying to argue this is a pertinent to a probate proceeding that doesn't exist. Because again, Miss Cowden is not deceased, and her husband has been deceased since 2004. There was an independent administration. It is long since passed. There's no court, the statutory probate court in Midland dealing with any estate issues, and that evidence is undisputed. And Mr. Caldwell seems reluctant to jump in. This is really, he's the probate expert here. If you'd like to explain a little more about that, Mark.
Well, I was just going to say, just because you have a will in a case doesn't make it a probate proceeding. We're talking about testamentary trusts that were established under a will that was probated almost 20 years ago. So the mere fact that there's a will does not get you to a probate proceeding. When we cited the common law test, which is what Mr. Dennis recited, that a probate proceeding is considered closed, well, at least an independent administration is considered closed by operation of law when all debts have been paid and all assets have been distributed. And so there is no probate proceeding. And just because there's a will that creates some testamentary trust almost 20 years ago, doesn't mean it's a probate proceeding either. And the special power of appointment that we're talking about was not exercised by Margaret in her capacity as executor of Courtney's estate. That's an individual right that she had under his will. So there's really not a probate angle here, Judge.
Judge, this will was probated in Midland County. I don't even know how they can contest that. Courtney's will was probated in Midland County. The Estates Code says that any cause of action related to a probate proceeding, contested or uncontested, has to be brought in the same county where the probate was pending. It doesn't say that the probate must be currently pending.
Yeah, this is an action.
The plaintiff drafted these causes of action all on her own, which implicate the will, the administration of the will, and the probate proceeding that was pending in Midland County. The Midland County Court that appointed Mrs. Cowden as executrix of the estate, which is what they're complaining about, some action she took while executrix. The Midland County Court that appointed her executrix has the exclusive right to hear this dispute.
That statement is absolutely false. We don't bring a single cause of action against Mrs. Cowden at all. We don't have any actions against what she did as executrix. The opposing party, the Swallows, were agents that took advantage of Miss Cowden. This is not an action against Mrs. Cowden, who's incapacitated. It is her daughter who took over as trustee, who under investigation found out that the Swallows both charged, $1 million+ to cash royalty checks. That's some of the money we know about, and also purported to potentially have her set up a will. That's why that references the special power of appointment, had her set up a will that creates another trust for them to compensate themselves with as permanent trustees. So that's the investigation part of it. But primarily, this is about them overcharging the trust for the work that they did. And you can't say it's a pertinent to a probate proceeding when there is no probate proceeding pending. It happened in 2004. It's long since the debts have been paid and all the assets have been distributed, and they didn't deny those facts. Again, the venue facts, they have to deny and put in evidence to support what they're saying. All they did in their motion was deny some very simple facts, which is, and I'm looking on page 2 of their motion, and all they deny is, they say in particular, the defendant specifically denied that this court has venue over this matter under section 115.001, that venue is mandatory in this court pursuant to 115.002, and that the situs of administration for Trust A and Trust B is in Dallas County. They do not deny that all the debts have been paid from the 2004 estate. They do not deny that that is not an estate pending, or that there are any distributions that are still owed. They don't offer any counter declarations either. And so again, I'm under the standard that's provided.
I guess what Mr. Dennis, let me tell you where I'm struggling with this, because I'm inclined not to transfer it, but where I'm kind of having difficulty is under 8.61, a declaration as to whether Margaret has validly exercised the special power of appointment granted to her. Is Margaret Swallow, or Margaret? Who's
Margaret Cowden?
Yeah, it's Margaret Cowden, the mom.
The mom, so the executor.
Correct.
Well, I guess she was the executor. She's no longer taking the acts as executrix. Again, that estate was from 2004. She's incapacitated, which is the reason that our client became the trustee.
But just to jump in real quick, Judge, her exercise of a power of appointment would not be something that she would do as executor of Courtney's estate. That was a power that was conferred on her by the will. But again, just because there's a will doesn't mean there's an estate, right? There's multiple ways you can create a trust. You can create a trust inter vivosly during your lifetime and set it up, or you can do it through a will, and it's called a testamentary trust. But the administration of a testamentary trust is something completely different from the administration of the decedent's estate.
Maybe that's where I'm getting. I'm having difficulty, which is it refers to the will. It doesn't refer to the if it was a power. I guess maybe it's just the way this is worded. It says a declaration as to whether Margaret has validly exercised the special power of attorney granted to her in section 4 of Courtney's will. Is section 4 deal with the establishment of the trust?
Well, there's multiple provisions in the will that the majority of the will does deal with the testamentary trust. And so when you look at the will, there's all these powers and administrative powers and whatnot in there that have to relate to the trust. The actual part that has to deal with the estate is very, very small. So I think we're getting lost in sort of the semantics that they're saying, well, there's this trust agreement and it was established in under a will, and so therefore there's an estate and blah, blah, blah. No, it's not, it doesn't work like that. The will is just the governing document in which all these trust provisions are found.
And
That's
to be,
it.
to
Plain
be
and simple.
clear, the power of appointment that's being discussed there, Your Honor, is what she is purported to have done under the Swallows' influence with her own will, not her deceased husband's will. When she's setting up her own will, and of course she's not deceased yet, what we understand without knowing is that the Swallows took her an attorney where a power of appointment, which is originally granted to her under her husband's will, but wouldn't be effective until she has her will and then passes away, in which she's trying to move the trust to another trust that the Swallows would be trustees for and receive income. And so that's what that section of the complaint is intended to address.
So Judge, if I could sum up the plaintiff's argument, when they say Courtney's will, they don't mean Courtney's will. They mean Margaret's will. I suppose Margaret's not dead, so she can't have a will or an estate.
She can
When
have
they
a will.
say the plaintiff drafted this petition herself, she complained about Margaret's acts and omissions while executor of Courtney's estate under Courtney's will. That is all that that declaration seeks, is with regard to Courtney's will and Courtney's estate, which is pending, but that doesn't even matter. It doesn't matter if it's pending or not. Any cause of action related to a probate proceeding, whether open or closed, must be heard in the same court that heard the probate proceeding, and that is the county court in Midland County.
Yeah, so just in response real quickly again, this declaration does not complain about whether Margaret exercised a special power of appointment granted to her in section 4 as executor of Courtney's estate. That's not what a power of appointment is. A power of appointment in the will was granted to her individually, not as executor. So we're not
I guess
complaining.
maybe,
It's a
can someone
distinction.
share screen section 4 so I can see, because it seems to come down to that section. Stop sharing.
And Judge, that is a distinction without a difference in the end, because you're still talking about the probate of Courtney's will and his estate. It doesn't have to be pending, although his estate is pending in Midland County, but it doesn't have to be pending. Any cause of action related to that probate proceeding has to be brought in Midland County Court of Law.
Let me share from section 4.
And Your Honor, I heard you want us to share a section with you. I couldn't hear which one.
Section 4, the one that's referred to here. Is it section 4?
Yes, Your Honor. So here you see that he's granting Margaret a special power of appointment.
As trustee, you see at the top, in part A, where she has the trustee for the benefit of his wife, hold on, stay with her, where Margaret Price Cowden until her death following mine, as she shall in her absolute discretion appoint from time to time during her lifetime by deed and upon her death by will. However, such power of appointment by deed may not be exercised with respect to trust B assets. So this is a lifetime power of appointment granted to her as trustee, not executrix, to dispose of assets of the trust in her will or via lifetime by deed.
And I guess there's more than one trust that's because it says she can't do this for trust B, I guess.
There is a trust A and a trust B as articulated in the petition, and I'm going to get them wrong, but one is like a pour over marital trust and the other is a second trust for the benefit of the children. And then the marital trust is in turn intended to all consolidate into the children's trust on her death. Mr. Caldwell, you have to correct me if I'm wrong on that.
No, that's effectively right. There's a bypass in a marital. That's correct.
So you wouldn't exercise the power of appointment that we're discussing here as executrix. This is something, as it indicates, that once the trust is set up as trustee, she could exercise a power of appointment during her lifetime or by will at her death. And while that's not the primary motivating purpose of the lawsuit, it's one of the issues that was raised in addition to the fees that were charged to her by the Swallow as well. We contend she wasn't in a position to, I guess, oversee it and realized that the trusts were being taken advantage of. They also took her to get a new will done in which they exercised the power of appointments under the trust. So it's not complaining about something that happened in 2004 as executrix that she did. The complaint is, what did the Swallows do with respect to that power of appointment in a new will by her? And the reason, I won't go too far into it, is there's just an incredible amount of complication in terms of taxes. While it would benefit the Swallows to set up, sort of follow-up trusts to the ones that were established back in 2004 so that they could be trustees, it may result in millions and millions of dollars of unwarranted taxes against the children, all of which support this action.
But Mr. Daigle, it does seem to be that section 4 of the Courtney's will talks about the power of appointment involving the trust. It's not power of, it does. I do tend to agree with Mr. Dennis. That's what it seems to say. So what's your last argument here?
Sure. The authority granted to Margaret for the power of appointment flows directly and only from Courtney's will. That authority is given to her by Courtney's will. Courtney's estate is pending, but that doesn't matter. It doesn't have to be pending because they're suing over for a declaration in part for how Margaret exercised her power of appointment given to her by Courtney's will. That is a cause of action that relates to the probate proceeding in Midland County. In this case, has to be.
Yeah, it seems to me that what we have here is this was part of the establishment of the trust. With that reasoning, anytime a will sets up a trust, you would have to hear it in the probate court. And I don't think that's what the estate code says. So at this point, I'm going to deny the motion to transfer. I do think it's kind of an interesting issue. If there is an amendment to the petition that implicates I'll just say this of Mr. Dennis, is if, depending on how this goes, if it does start to drift into areas, if you amend your petition that where it clearly implicates the probate of the will, then, in some kind of amended petition or something like that, I'll reconsider the motion to transfer, a new motion to transfer. But based on the status of the case at the moment, I think it's transfer is not required, and I'm not going to transfer it. So have you submitted an order on that, Mr. Dennis?
I believe we have, Mr. Caldwell.
I think we have one drafted. I'll have to double check and see if it's been e-filed, but if it hasn't been e-filed, Judge, we'll file it right away.
I don't see one unless you attached it to the motion. So
we'll get it.
Judge, just so I can get my record clear, you're denying the motion to transfer venue under Civil Practice and Remedies Code 15.002 and 15.011.
I don't think that's correct.
That's two other mandatory venue provisions that require this case to go to Midland County.
both Henry Wheeler and JP Morgan out of the San Antonio Court of Appeals say that trust code trumps any section 15, and the section 15 mandatory venues don't apply anyway. For example, we're not seeking an interest in property. Just because the trust owns property doesn't support that. But
That's not what it requires. It's for damages concerning real property, which this lawsuit unquestionably does. And none of that real property is located in Dallas County or North Texas.
Okay, I already rolled on this, so thank you guys. Just get me in order, and you guys have a great rest of your day. Okay,
Thank you, Your
Thanks,
Honor. Appreciate it.
you guys.